Hi friends, this is Lokesh Pathak with you again and welcome to the fifth class of Jurisprudence. As committed, today we'll discuss about the historical school of jurisprudence. So before we go to the details of the historical school, first we should understand what are the highlights of this school, what this said. Because earlier we have seen that natural school it concentrated on morality and the divine things, while the Austinian or analytical school it concentrated on the positive law and analytical things. Now, historical school, I found it more relevant as compared to two because it tried to arrest some of the drawbacks of both of the previous schools. So, historical school it is based on certain sayings of certain jurists belonging to that period. So, as per Montesquieu, what we discussed yesterday, Montesquieu is the one who gave the empirical theory of law, and he is the only exponent which is common in sociological school of jurisprudence as well as historical school of jurisprudence. So, Montesquieu's empirical theory it gave the finding that the laws are the creation of climate and local situations. So, this is one of the important aspect of historical school of jurisprudence. So, another exponent, which is Hugo Grotius, he said that essence of law in its acceptance, regulation, and observance by members of society is the basis of historical school of jurisprudence. Although he does not belong to that time, but his saying was used. So this school came as a reaction to natural law school. And the basic source of historical school is habits, customs, and usage, which means that the habits and the customs what people follow and the usage what they make in the society it governs the actual law. Historical school it emphasizes the man-made laws. It says that laws are made by the people for the people. It also says that law should be changed as per the needs of society. It should not be unchanged. Rather, it should be changed as per the mentality and as per the society grows culturally. The important assumption of this school is that law is found, not made. However, there are some contradictory views if you see, because once you say that people are making it or they are getting it evolved, you cannot say that it is just found. Anyways, that is another point of criticism. So before we go further, we should know what is the difference between historical jurisprudence and legal history, which we should not be confused between the two. The historical jurisprudence it examines the manners, circumstances, and factors in the growth of law, and it takes into account social forces which are operating in the process of evaluation of law. While legal history is different, because legal history it is basically a factual narration of development of law in various legal institutions in a chronological order. So it's basically a narration in a chronological order, while historical jurisprudence it examines the manners, circumstances, and factors in the growth of law. Now, historical school of jurisprudence it has five main exponents, and those are Montesquieu, who is common with the sociological school also. Then the Savigny. Savigny is the father of historical school. Then Friedman. Then Sir Henry Maine and Frederick. So we'll take them one by one and what they have said and how they contradicted each other, how they developed, that we will see. The first one is the Montesquieu. The period of Montesquieu is 1689 to 1755, and he gave the empirical theory of law. He said that law is a creation of climate and local situations. And if we elaborate much on this, he said that it is made of climate and other factors like social things, environment, and customs, etc. So he gave that statement in his famous work, which is the Spirit of Laws, written in year 1748. He also said that for evaluation and development of law, the cause and effect of social surroundings and biological environment is responsible. So it means that law is nothing but the consequence of causes and effects of social surroundings, like what are social things around us, as well as biological environment. So we can see that he gave importance to social things. And he said that because of this basis in his theories, he is said to have laid the foundation of comparative and sociological jurisprudence. Before we go forward, just to add that the historical school is also called the continental school. So if somebody asks you what is a continental school, don't get confused. It means the person is talking about the historical school of jurisprudence. So now the next exponent is Savigny, and he's also called the father of historical school. He gave a famous theory which is called Vogtis Theory that we'll discuss now. But first of all, let's see what he believed. Savigny said that law cannot be borrowed from outside. And he further said that the main source of law is consciousness of people. He also said that law dies or fade away when nationality loses its effect. So you can see that he gave the much of the weightage to the consciousness of the people or the spirit of the people. And he also related nationality, the factor of nationality in the development of the law. He gave a Vogtis theory, which was a basic concept of Savigny, and there he emphasized the national character of forming a law is the spirit of the people. And he then gave a definition of Vogtis nation also, which is run by the law, which is dependent or made up of spirit of the people. His Vogtis theory received criticism from two of the famous jurists, which is Charles Allen and Professor Stone. Charles Allen challenged him. He told that customs or the spirit of the people. These are not the outcome of the common conscience of the people, but these are the outcomes of interest of powerful people. So he told, as per Charles Allen, this theory is not relevant because the dominance in the society is not from the spirit of the people, but it is because of the game of the powerful people in the society. Also, Professor Stone criticized him that he did not consider the efficiency of planned legislation and codified law. So that was another criticism of Savigny's theories. However, Friedman, which is a third exponent, he concluded Savigny's theory. He made some improvisations in Savigny's theory. He said that law is like a language which eventually grows. And also he told that law is found or discovered, it's not made, which means you cannot just make it like artificially in like an invention of an object in a laboratory. It has to be like it should be discovered and not just artificially made. You discover, you see what are the consequences of existing law, you keep on discovering, you keep on improvising. You cannot just like that artificially impose some law on the people. So that was the emphasis what Friedman made. The fourth exponent is Sir Henry Manning. Sir Henry Manning is also called the founder of English Historical School because he carried Savigny's view to England. He gave some major and excellent works. Two of them are Ancient Law Book, which he published in 1861, and there is another book which is based on the village communities, which he published in 1871. He wrote another interesting book, actually two of them. Those are Early History of Institutions in 1875 and Dissertations of Early Law and Customs in 1883. Close to 1861, from 1861 to 69, he has been to Governor General of India also. So he was quite aware about the Indian law and how it works. What Sir Henry Manning did, he took the positive points from Savigny's theory and Montesquieu's theory. He took the best part of it and he developed it. So we have just seen that what were the prime drawback of Savigny's theory, that it lacked the codified law and statute. So he took that component and he emphasized on codifications along with the customs. So we can believe in the spirit of the people, we can believe in the customs, but at the same time we should work on codification of law. So that was the need he emphasized. So he described the development of law in 4 stages. The first stage, he said, which is based on the rulers. When ruler under the divine inspiration, they gave the verdicts. The second stage, he said, that when a ruler would have given their verdicts, then that command of king is converted to the customary laws. In the third stage, he said that those customary laws, they go into the stage of knowledge, management and administration. And in the last, which is the fourth stage, those commands becomes codified laws. So he told that this is the development stages. Based on these four stages of development, the law from verdict to the codification survives. He also related this with two sort of societies. He said that there are two types of societies. One is static and another is progressive. The static society stops at the fourth stage, which we just discussed, while the progressive society, it also develops the law even after the fourth stage is passed. It continuously improvises and reviews the law which is codified and developed with various instruments. And these instruments are legal fiction, equity, and legislation. I'm repeating these instruments. There are three instruments. One is legal fiction, means you think about the things legally and then you improvise. And then equity, which helps to remove rigidity in the laws. And then legislation, which is basically the operation of law. So modus operandi is through legislation. So the fifth jurist, Frederick, there is not much told about George Frederick because he just supported the theory of Sir Henry Manet. So it's worth to mention his name, but not much to his account because he just followed what Sir Henry Manet has said. So based on these five exponents, we have seen that historical school of jurisprudence, how it grows, what is emphasized. So you see that it came as a reaction to the natural law school. It emphasized on the man-made laws by the people for the people, and the main source of legislation in historical school was habits, customs, and usage of the people. It's different from legal history, we have seen. Then we have seen the various exponents, which include Montesquieu and his empirical theory. Then we discussed about Savigny, who was a father of historical school, and his Vogtis theory. Then we discussed about Sir Henry Manet and the development of stages he described, and he told about the static and progressive society and legal instruments also by which the development continues. And then we have seen what Frederick has told. So this is all about historical school of jurisprudence. In the next session, we'll talk about the sociological school of jurisprudence. Stay tuned, stay commenting, happy learning. Bye.